All right. Whoops. Not sure what happened to me. Okay. The couple things I've got the record set up, so we're going to get on the record in 1 second. But lawyers, we've got Miss Armstrong that we're going to lose in 24 minutes. So, and Miss Armstrong, do you know how long your hearing is with Judge Morgan?
I don't. It's an enforcement of contempt with contempt. So I'm not sure.
Okay.
I may have a better, once we do docket announcements, I may have a better idea.
All right. And Ms. Pierce and Mr. Schwartz, there was a request by Ms. Pierce to have the enforcement hearing separate from the child support modification. I want to get everybody's position on that. I guess, Ms. Pierce, if you'll tell me why you'd like to have them tried separately first for the record. And let me get on the record. The court's on the record in cause number 17 DCV 247092, the Bachelor matter. Counsel, if you would please each identify yourselves and the party that you represent, beginning with petitioner.
Hoya Armstrong, representing the Office of Attorney General, with the petitioners on a modification and a confirmation of arrears.
Go on, Don.
Don Schwartz, representing Amy Lee Bachelor. Go ahead, Lisa.
Lisa Pierce, attorney for cross petitioner Darren Bachelor, and respondent in the enforcement.
Ms. Pierce, you had a request that the court hear these matters separately. If you would, please, you can go forward on that argument.
Yes, Your Honor. My client would like to proceed on the enforcement first because he believes in an effort to prove up the modification and the entitlement to that. He might be forced to make some admissions that would be incriminating in an enforcement. And so we are requesting that the enforcement be resolved. And then the reasons for the modification, that he can testify freely as to those reasons, Your Honor.
All right, Mr. Schwartz, response?
Yes, we object, Your Honor. These two matters are inextricably intertwined. As the parties got divorced over 10 years ago, the first matter was, the first enforcement was brought in 2015 when he was $8,500 below. He was an $8,500 in arrear.
Hold on, Mr. Schwartz. The objection's relevance?
Yes, he's going back before the last order.
All right, the objection sustained. I understand, Mr. Schwartz, you're opposed to trying them together because you think that the material covers the same evidence. Is that right?
That's correct, Your Honor.
All right, Ms. Armstrong?
Well, they kind of do, Your Honor. My office filed a motion to confirm arrears, which means I'll have to submit a pay record into evidence. I'll have to talk about his unpaid child support when I do my confirmation of arrears, which is coupled with my modification.
Right. So my thought is that what I would do is, because Ms. Armstrong, you don't have, you're here on the modification. You're not really here on the enforcement, correct?
Correct. I'm not here on the enforcement. I do need to confirm arrears. That's part of my petition, but they could do that in the enforcement. They have to confirm arrears as well. I did submit my pay records. If the parties could stipulate to my pay record and use those numbers, then that would be great.
Your Honor, we have pled for and requested, and the state has too, a retroactive reduction. So I am opposed to doing that in the enforcement until the court rules on whether the court's going to retroactively reduce his child support. I don't want to confirm the state's arrears until that's, unless we're only confirming to January 31st, because I'm requesting retroactive reduction back to February 1st. So I am opposed to her exhibit coming in as is in the enforcement, Your Honor, because the court's going to have to determine to confirm the arrearages whether they're going to grant the modification back to February. That will change the state's exhibit.
So to me, it sounds like what I'm going to do is, since I don't necessarily need Ms. Armstrong for the enforcement, is I'm going to let her go. We're going to hear the enforcement matter first, and then we'll take up the modification immediately after, hopefully, if we get Ms. Armstrong this. Like, Ms. Armstrong, do you think there's any chance you'll be available for 1:30 if I resume or start the modification at 1:30 this afternoon?
I think I should be, yes, Judge.
So that's probably what we'll do is I'm going to hear the enforcement this morning, and then I'll take up the modification at 1:30, a modification and request for confirmation of arrears at 1:30. Okay, so Ms. Armstrong, you're released until 1:30.
Thank you, Judge. I'll see y'all then.
Thank you. All right, we're going to proceed on the motion for enforcement. Mr. Schwartz, this is your motion, but if I can get the parties to please start their video or get on camera so I can swear you in, or anyone that's going to testify. All right, Mr. and Miss Batchelor, if you would please raise your right hand to be sworn. Other hand, sir. Each of you solemnly swear or affirm the testimony that you're going to give in this cause will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
Yes.
All right, thank you. You may put your hands down. All right, Mr. Schwartz, this is your motion, so you'll be allowed to go first. And if you'd like to give me a brief opening, you may do so whenever you're ready.
All right, Your Honor, for opening, like I said before, that these parties were divorced in 2010 and the first the defendant here, respondent, has been continually in arrears ever since they were divorced. In 2015, the Attorney General's office was involved, and we filed, and then we later filed a motion to enforce child support. But according to the Attorney General's records, in 2015, Mr. Batchelor was in arrears of $8,500 plus. And in 2017, we proceeded and we reached an order, and that order is in the court, and we're asking the court to take judicial notice of the court's prior orders. Since 2019, he has been still in arrears. We have not requested that he be put into jail, but this man has developed a pattern of being employed, making money, and not paying child support or medical support. And this has continued up until today's date. Mrs. Batchelor presented him with some medical payment bills for reimbursement, and he didn't even receive or accept the certified mail. And with regard to the medical support, he has been continuously in arrears as far as even making minimal payments of less than $50. And if we look at the Attorney General's report, which
Your
is
Honor, this is
exhibit
improper argument.
1 and 2.
Hold on. What's the objection?
Improper argument. He's testifying. He's not saying the evidence will show. I just believe it's improper argument.
Overruled, but Mr. Schwartz, just stick with what you think the evidence is going to show.
All right, I think the evidence is going to show, Your Honor, that one, he has been continuously denying the court's order or even complying with the court's order. He does not have any respect for the court. Two, my client has incurred medical bills without being reimbursed, and he is in arrears. We believe $6,225 on child support, and over $3,000 in medical support. And these are all supported by not only our exhibit list, but also exhibits 1 and 2 of our petition. And we're requesting the court to put some restrictions on him, whether it be in jail or that if he does not comply with the with the current orders that he be put in jail.
All right, thank you, Mr.
Because without any penalty, he's just going to continuously shun the court's orders. He won't pay any attention to them. He hasn't done that for 11 years.
All right, thank you, Mr. Schwartz. Ms. Pierce, would you like to give your opening at this
Well,
time?
just in the enforcement, Your Honor, I assume we're proceeding under the third amended motion for enforcement.
I was going to cover that after the opening
Okay.
statement, but yeah, so let's cover that now. There was a third amended motion for enforcement filed on November the 9th of 2021. And just prior to going on the record, the court had addressed that issue with Ms. Pierce because I felt like there might be a notice, or not felt like, there's a notice issue under the code. But Ms. Pierce, it's my understanding that you and your client are waiving that 10 days notice to get ready for the hearing, and that y'all are prepared to go forward on the third amended motion for enforcement this morning. Is that correct?
That is correct.
So we are going to proceed under that motion. Ms. Pierce, you may proceed with your opening.
Yes, Your Honor. If the contrary to what Mr. Schwartz is saying, the evidence would show that this man has paid over $300,000 in child support since the divorce. And contrary to what Mr. Schwartz stated, his motion numbers 7 and 8 are specifically requesting for contempt and jail. And Your Honor, we believe that the evidence will show that my client has defenses against their motion for enforcement, and we intend to make those known to the court at the proper time. And that's all I have, Your Honor.
Thank you, Ms. Pierce. Mr. Schwartz, you may call your first witness.
All right. First witness is Ms. Batchelor. Would you state your name, please?
Amy Batchelor.
And Miss Batchelor, were you at one time married to Darren Batchelor?
Yes.
And were you later divorced
Yes.
in 2010? Is that
I'm not sure of the date. I think it was 09 or 10.
okay? And during that time of the marriage, how many children did you have?
4.
4 children. And how many of those children now are minors?
1.
1. All right. And tell the court that child's name.
Brennan Batchelor.
Brennan Batchelor. And have you complied with the court order as far as giving notice to Mr. Batchelor with regard to medical payments?
Yes.
And have you done that by certified mail?
Yes.
At approximately what cost?
It's about $7 every time.
All right. And you have read the pleadings, is that correct?
Yes.
And looking at the pleadings, can you tell us, has Mr. Batchelor ever been current with his child support?
With child
Your Honor,
support?
Yes.
Your Honor, at this time, I'm lodging a Slavin objection for insufficiency of the quasi-criminal proceeding. There's no specific counts pled. There's no order cited in the pleading, and I'm requesting dismissal with prejudice for the violations through today's date.
Your Honor, we're asking the court to take judicial notice of the court orders, and there was a divorce decree entered. Was there a divorce decree entered?
Yes.
And did the divorce decree ordered him to pay child support? Is that correct?
Yes.
And has he?
Just 1 second,
Your
Mr. Schwartz. I need you to, there's a motion to dismiss that was an oral motion to dismiss that was lodged by Ms. Pierce. So before we get back into the testimony, she's arguing that the third amended motion for enforcement is not specific enough in that it doesn't have alleged specific violations of what you're alleging, or Ms. Batchelor is alleging that Mr. Batchelor how he did not comply with that prior order. So if you can address that oral motion that she's made for me, please.
Yes, sir. Your Honor, we reflected that the Attorney General's exhibit 1 and 2. The exhibits 1 and 2 show his arrearage and when he made payments and when he didn't make payments and the amount. Each of those dates is a violation because it's not in compliance with the previous court order. We entered and there was in April, we entered an order. It was all agreed to. And he hasn't complied with that order as shown by the Attorney General's report. The prior order that I'm talking about, of which Ms. Pierce and her client agreed to, that was signed by Judge Heppard, was dated April 16, 2021. He hasn't complied with that order, and now they're trying to overrule the order that they have previously agreed to.
Okay, give me 1 second. I'm reviewing your motion right now, your pleading. All right, Miss Pierce, if you would please let me know what specifically are your objections to the motion for enforcement under Slavin?
Oh, in number 5, he cited a Rule 11 agreement, which is not an order of the court. So the order is not cited. My client is not made aware of what order is moving forward. There's no specific violations attached. Furthermore, there are no missed payments on his attached Exhibit 1. So there's no order and there's no specific violations. Just calling a Rule 11 agreement dash final order does not make it an order, and it's not signed by the court. It's index 24 of the court's dockets, or whatever you call that thing.
All right, so the payment record is attached and is incorporated, which does show the alleged violations.
Which you're talking about Exhibit 1, Your Honor?
The Attorney General of Texas Child Support Division, it looks like it's there's 6 pages attached to, oh wait, that's a second amended motion for enforcement.
That's correct.
Hold on. I don't know why I had the second amended up. Give me 1 second. So in the third amended, there's just 1 page, Exhibit 1. Hold on, it's going to make the court do math. We're going to go off the record for a second while I review this. But I'm going to review Exhibit 1 real quick. So we're going off the record. All right, the court's back in the record. Ms. Pierce, when you get a chance. Mr. Schwartz, you mentioned in your pleading a Rule 11 agreement. Which
Yes.
Rule 11 agreement are you referring to?
Your Honor, that Rule 11 agreement is reflected in the judgment of the court that was entered and signed on
By Judge
the,
Stavanoa, August 6, 2018? Is that the one you're referring to?
yes, yes. Yes, correct.
Although, Your Honor, he cites Rule 11 Agreement Final Order, which is Index 24 of the court's record, in his pleading as his basis, and it is not an order of any kind.
There was a court order entered and he's in rearage pursuant to that court order.
Yeah, that the court order was dated August 6, 2018. It was signed by Judge Stavanoa. Let me go
That-
back to your.
That's correct.
Oh, okay, I see. So in his, I see her point. So in the movement's third amended motion for enforcement, your date is August 3rd, 2018, which is probably the date of the Rule 11. Let me look.
It's the date, it's the e-file stamp on the Rule 11, Your Honor.
Right. So you're referencing the Rule 11 agreement in the motion for enforcement, not the actual judgment, the order that was signed August the 6th. All right, so that's one issue we've got.
The Rule 11 also says final orders.
Yeah, I understand, but it's actually not an order. But the other thing is in that order, it orders him to pay towards that arrearage, $135 a month towards the child support arrearage, and then $100 a month towards the medical support arrearage. And I don't see that referenced in here. So give me 1 second. Give me 1 second. I'm going to pull the code section up and ask you a quick question, Mr. Schwartz. Just 1 second. All right. The court's back in the record in the bachelor matter. So my issue, Mr. Schwartz, is this. The I mean, this is a motion for enforcement, which is, as you know, quasi-criminal, because one of the requests is that I lock Mr. Batchelor up or potentially lock him up. And I can tell you that, as both these lawyers know, that's something that I and Judge Heppard, we do on a regular basis when somebody violates a court order. And I don't care if it's mom or dad or who, if someone's violating a court order, that's a problem that they have with the court, because the court can't maintain any kind of credibility with the parties if the court doesn't back up and enforce the order that the judge signs. And so you just need to be aware, that's my feeling as a judge, is I'll normally put somebody on probation the first time. And then the second time, they're going to go spend a little bit of time in the Fort Bend County Jail. That's just the way it is. And that's the way I think a judge should be. It doesn't mean that a judge is heartless and wants to put people in jail. It's the least favorite day I can tell you that I have as a judge is when I lock somebody up. But I do it because I have to enforce the orders of the court. Otherwise, there's chaos between the litigants. Because if they don't think a judge is going to enforce their order, why should you get to see your kids if you're not paying child support? If he's not going to put this guy in jail or have any consequences for not paying his child support, why would I let him see his kid? And so people take the law into their own hands because certain judges won't enforce their orders. And I can tell you, that's not me. The problem I have, though, is 157.002 of the Texas Family Code, which as a judge, I take an oath that I'm going to follow the law, says that before I can put somebody in contempt of court and put them in jail, that they're entitled to certain rights. And specifically 157.002 says that in a motion for enforcement, it must state in ordinary and concise language, identify the provision, one, it's got to identify the order, and then it's got to identify the provision of the order allegedly violated. And then it's got to state the manner of the respondent's non-compliance. The problem I have is it appears to me like in that one, I've got a Rule 11 agreement cited rather than the order. And I think that in and of itself is going to prohibit me from being able to find him in contempt under that provision of the code. But the other thing is, it looks to me like he's ordered to pay several obligations. And one is 135 a month on child support arrearage of back in August of 2018 was $8,520.22. He was also ordered to pay $100 a month on his medical support arrearage, which was $1,951.90. In addition, he was to continue paying his regularly ongoing monthly child support obligation. But I can tell you, looking at the motion, I can't tell what exactly he's failed to comply with. And so I can't see how I can hold him in contempt of court, and I've got to sustain Ms. Pierce's objection. That being said, this money, Mr. Batchelor, you need to understand this money is still owed. In the court, just so you're aware, all the court needs to find is one provision of an order that's not followed in order for a judge to hold somebody in contempt of court. So for example, you may pay everything correctly and then fail to pay the $100 a month towards the medical child support arrearage for, let's say, December the 1st, when that payment is due. And if you violate that one provision of the order, it gives me as a judge the power to lock you up for 180 days for violating that one specific provision. So this is not a get out of jail free card, and you need to understand that. I don't have what I have in front of me to be able to enforce the order today, but that doesn't mean that I'm not concerned about this case or that the child support's not owed. And it may be you didn't even get a chance to present your side of the case. I get it. You know, this motion for enforcement is going away before anybody gets their horse really out of the gates. And I know Ms. Batchelor wants to tell me a lot of stuff, and you may want to tell me, Judge, I've paid everything that I'm ordered to pay. I can tell from just looking at the pleadings in this file that there's been a history of non-payment. And that's always a concern for me because people rely on their child support checks in order to meet the needs of the child. And so it's something that if there's a history of not paying it on time, you need to be very cautious and understand you're on very thin ice with this court, because if you violate that order and there's a history of it, you're leaving me with very few options but to send a message. And that is, sometime in the Fort Bend County Jail. And I can tell you, I don't want to do that to you, Mr. Batchelor, but I will if the paperwork's in order and you're not complying with the court order. So if you have an arrearage, I would make arrangements with Ms. Pierce to get on some kind of payment plan to pay that so that it gets resolved. Because I have a feeling that if it's not resolved, there's going to be a motion for enforcement filed, December the 2nd, and with alleged violations that you didn't make your payments on December the 1st, and you're going to put me in a situation where I have to do something I don't want to do. All right. But I don't, Mr. Schwartz, I understand you attach the child support exhibit, and then a lot of times that's sufficient for this court. But because I don't have the actual order referenced, if I held him in contempt of court, it wouldn't be worth the paperwork that I signed. So
I understand, Judge.
I'm going to sustain that objection. That doesn't mean we're not going to have the modification trial. We need to have that today. I will do that at 1:30. And Ms. Batchelor, I'll say this to you, because I know you're probably frustrated that you feel like someone's not getting held accountable. This court will hold him accountable if he doesn't do what he's supposed to do. But you have to understand this is a criminal nature. And so for me to be able to enforce this order, I've got to make sure every I is dotted and every T is crossed. And that's not done today, which in my opinion prohibits me from being able to address it today. Okay, that completes the ruling of this court on the enforcement. I'll make a docket entry to that effect. We'll take up the motion to modify at 1:30, and y'all can just report directly back into my Zoom for that. And we'll see y'all back here at 1:30.
Your Honor, I can have clarification for my order on it.
Yes.
Since his exhibit 1 goes through today's date, can I state that you're denying the enforcement through today's date?
The enforcement is denied through whatever was pled in that third amended motion, which appears that
Exhibit 1 was dated yesterday. Oh, 8th.
Give me 1 second. I'm looking at what was exactly pled. So it looks like from what I can tell, the most recent alleged allegation would be in Exhibit 1, 11/1 of 2021. So, so that it would be through today's date. So the
Your
first,
Honor, I also pled for attorney's fees for every violation that I successfully defeated. Can we have my attorney's fees testimony?
well, you can testify about attorney's fees if you'd like to. Go ahead.
Or would you like to? Well, okay. I'm sorry, Your Honor, I've got to get the code out of my way. May I have permission to testify in the narrative?
May.
I'm a licensed attorney in the state of Texas, competent to testify as an expert as to reasonable and necessary attorney's fees in matters of this kind in Fort Bend County, Texas. I am familiar with the reasonable and necessary rate for family law cases of this nature. My hourly rate is $250, and Darren Batchelor needed representation to protect the best interest of him and his child. My fees are for time spent researching, preparing pleadings, meeting with the client, discussing the litigation with the client, preparation for the hearing, and my time today. I have spent, I got to look at my exhibit. I'm sorry, Your Honor. $1,208.75, I believe. Your Honor, I'd like to offer petitioners 9. Not, respondents 9, I'm sorry.
Any objection, Mr. Schwartz, to respondents 9?
Yeah, I would like to take her on cross.
You can cross her on it. I'm just right now, I just want to know if you have any objection to R9.
I don't have any objection to 9,
All right, R9's admitted.
as just as what her testimony would be.
Yes, sir.
Okay, Your Honor, may I share so I can? Oh, no,
You may.
okay. I'm sorry, I have a lot of exhibits. Why did I'm sorry. I'm trying to find it. I'm struggling with my own inabilities. Good grief. I don't know, Your Honor, why I can't find it all of a sudden. I'll have to just look at it and testify, I guess.
I have it in front of me, Ms. Pierce, so I can follow along.
Oh, okay. Thank you. So my, if you go to page 6 of my exhibit, I have 5.75 hours. My bill's completely bifurcated between the enforcement and the modification. I have 5.75 hours in July. I have 3.75 in September. And I have 1.5 up until today's date. And I don't know how much the court considers we've spent today. So 5.75, 1.5. Oh, I'm sorry. 3.75. 0, 5. I think that's 10.5 hours, Your Honor. At $2.50 an hour. No, that's not right. $2,625 in defending this enforcement. This is our 3rd setting. I'm asking for a judgment for attorney's fees in the amount of $26.25. And I ask that they be awarded as a judgment in favor of me with interest and be ordered paid directly to me.
You passed yourself?
Yes, Your Honor.
Mr. Schwartz, any questions of this witness?
Yes, Your Honor. What she's stating is that for the most part, the issue has been reduction of child support. The issue has been the amount of child support that he's in arrearage. We would not be in this position had he not been in arrearage.
But Your Honor, is he supposed to question me? Isn't he?
Well, yeah, Mr. Schwartz, we're gonna get argument in just 1 second, but do you have any questions of Ms. Pierce?
Yes, I do.
Okay, go ahead.
Ms. Pierce, you'd have to agree that First of all, you wouldn't be in this position if your client was not in arrears, correct?
I disagree. I wouldn't be in this position.
Well, your client wouldn't be in this position. You're representing your client, but had your client been current on his child support payments, he would not have had to employ you, correct?
I'm going to object to relevance.
Overruled.
Uh, Had your client not filed an enforcement, my client would not have incurred these attorney's fees for an enforcement. That is correct. There was already a motion to confirm arrearages pending before the court, which would have confirmed any amounts of money owed to your client.
Yes, and we haven't been able to go forward on that because of court dockets. Isn't that correct? And your employment was not only with regard to any enforcement issues, but the fact that your client was in arrears. And there's been no distinction made in your bill as to what amount of attorney's fees was specifically towards the enforcement issue, as opposed to just discussing with your client the amount and how he was to pay his support.
That's untrue. Every one of my bills is bifurcated by modification and enforcement.
But your bill is for representing him not only in enforcement, but also for the arrearage issues.
I'm only asking for a portion of those bills related to the enforcement in this particular enforcement trial. I will address the other attorney's fees as to the modification in the modification trial.
But there's no exhibit that differentiates what you have charged for each issue in your bill.
I believe it's on pages 6, 7, and 8. It's differentiated.
Your differentiation is where now on what exhibit?
Exhibit 9, pages 6, 7, and 8. I believe I'll have to look myself to make sure.
Well, I'm looking at let me see, exhibit 9, page 1 of 1. Says exhibit 9-090721, invoice 14794.
That's my exhibit's 8 pages in total. I'm only referring to pages 6 through 8 for purposes of the enforcement trial. It says 1 of 1 because each individual invoice was 1 page of 1. It's
All right. And you're asking for how much?
2625, I believe, is what I said. I've got to look at my math again.
The testimony was 2625. The court heard that, so if that helps.
Okay, yeah, I'm sorry, I thought I answered, Your Honor. I did find it on my calculator. My phone keeps going, the screen keeps closing and I lose my calculator.
Mr. Schwartz, any other questions of this witness?
No, I don't have any other, Judge. Now, also, you're going to hear our request for a judgment. Is that correct also?
That's going to happen at 1:30. We're going to deal with that today as well.
Yeah,
Okay.
because my pleading is for enforcement as well as a judgment plus interest.
I understand, but there's a request for a retroactive.
Yes.
That's going to impact what we do on that. So we're going to hear all that in the modification. So I just wanted to deal with the enforcement aspects, but we're going to take care of that request, Mr. Schwartz, this afternoon.
And with the judgment we're having a hearing, but it'll be one judgment for both, right?
It'll be, well, a lot of times I think the AG wants to set those up kind of like y'all did in that judgment where you have two separate judgments. So there's a child support judgment and then a medical support arrears judgment. But we'll once we have Ms. Armstrong in here, we'll deal with that.
All right.
Ms. Pierce, any redirect?
Redirect, I'll briefly call my client.
Okay, you may proceed.
Mr. Batchelor, can you state your name for the court?
Aaron Batchelor.
And Mr. Batchelor, was a motion to confirm arrearages already on file with this court in December of 2020?
Yes,
And as your attorney, I filed a cross petition to modify in March. Is that correct?
yes,
And shortly after that, did Ms. Batchelor file a motion for enforcement?
yes,
And was the issue of the arrearages already going to be handled by the AG? By the
Yes.
Attorney General? I'm sorry.
Objection, Your Honor, as to what he thought of what the AG was going to do. It's
Sustained.
Did the Attorney General have pleadings on file to confirm any arrearages that might exist?
yes,
Would that have taken care of Ms. Batchelor's concerns about getting any arrearages paid to her?
objection, Your
Yeah.
Honor. He doesn't know what the Attorney General would do.
Well, as far as her state of mind, it's sustained as conjecture.
Do you believe this enforcement was filed in retaliation of you seeking to lower your child support?
Objection, Your Honor.
Overruled. You may
yes,
answer that, sir.
yes.
And why were you having to have your child support amended?
Can you repeat that?
Why were you having to have your child support reduced?
Because I got laid off. I was on unemployment because of the COVID.
And what industry were you working in at that time?
It was the oil field.
And would it be accurate to state when oil is good, so is the money?
Yes, ma'am.
And would it also be accurate to state that that industry goes through a lot of ups and downs?
Yes, ma'am.
And did you attempt to have a child support review in September of 2020?
Yes, ma'am.
And would Ms. Batchelor agree to the reduction?
No, ma'am.
And so do you remember how long it took for the Attorney General to file a modification for you?
It was about 3 or 4 months.
And what was happening during that 3 or 4 months that you were waiting for that?
I was on unemployment, still paying the big amount.
And did that have any, was there any result of that to you? Any negative consequence to you?
Yes. They repoed my truck. My house went into foreclosure. Several different things, but it just, the money wasn't there no more once I got laid off. I couldn't afford.
And and is it true that even though your the modification was filed in December, the AG didn't have a setting until June?
Yes, yes, ma'am.
And what were you going to have left by June if something didn't happen?
Ma'am,
What were you going to have left by June if you had not had me intervene?
nothing. I
Columbia
wouldn't have a
Lakes.
house. I wouldn't have nothing.
Are you on the, do you still owe me for these attorney's fees that you've incurred?
Yes.
That's all I have, Your Honor.
Mr. Schwartz, any questions of Mr. Batchelor?
Yes, Your Honor. If you, now, you said, Mr. Batchelor, that when you got laid off, you weren't paying child support when you got laid off, were you?
Objection, Your Honor.
Yes, so,
Well, I was only addressing attorney's fees issues, not the modification at this portion. So relevance is,
I feel like we opened the door a little bit on that. So overall.
okay.
That's sir.
Okay.
All right. And you were employed by Columbia Lakes, isn't that correct?
that was later on, in November or no, wait, yes, in November the 15th.
And you continued to work for Columbia Lakes, is that correct?
Yes, and they took out the full child support. I didn't even get half my check.
And you weren't paying child support when you were receiving checks from Columbia Lakes, is that correct?
Objection, that misstates the evidence.
Overruled. You may answer that.
Yes,
sir.
I was paying child support.
How much were
Like
you
I
paying?
said,
You weren't paying the amount
$1,500.
that you were supposed to, right?
$1,500 a month. That's what I'm saying. They took out more than half my check. That I wasn't even getting. So they didn't reduce the child support. I wasn't making but $18 an hour. Nothing like I used to make. And so they still took out the $1,500. And I think it was well, we'd be happy to be $750. So I didn't give like $600 and something every 2 weeks.
So this was what year were you laid off?
I was laid off April 30th, 2020.
All right. Now, if looking at the child support, you weren't paying $1,500. Were you paying $1,500 a month when you were working for Columbia Lakes?
Yes, I was paying the full amount.
Well, if
Okay.
I'm looking at the child support records, it shows that
Your Honor, I'm going to object to
in
testifying to a
March of
document not
20
admitted into evidence.
Well, it's that can be admitted, but I think we're getting into something I'm going to be hearing this afternoon, because what he did or didn't pay is going to be part of that confirmation of any arrearage. And I really don't want to hear it twice. I'd rather us just do that this afternoon.
I agree, Your Honor. I withdraw the question.
Okay. Anything further about attorney's fees of this witness, Mr. Schwartz?
Yes, one other thing. with regard to filing a motion to have it reduced, you have hired several lawyers during this, after your divorce with Ms. Batchelor, correct?
Objection, relevance?
Overruled. You may answer that, sir.
Well, Your Honor, time
Yeah.
frame then, objection time frame. If he's asking all the way back to 2009, I'd like him to be more specific.
That's what his question was 2009, right? After the divorce, sir?
Yes, that's correct.
Overruled. You may answer that, sir. Have you hired several lawyers since 2009?
Yes,
All right. And so you knew that when you lost your job, that there was an avenue that you could utilize, or that there was you could go to court and ask for the court to reduce your child support. Is that correct? You did it with Miss
Yes.
Browning, right? Miss Brown?
Objection, time frame?
yeah, but
Ms. Brown?
that wasn't,
That was
yeah, I
in
had this
2000,
Brown.
2017, 18, correct?
Right. Right.
And you got your child support lowered then, right?
That's because, because of one of the children had turned 18 and graduated. It wasn't because of this. I had to go to court because one of the children had graduated and turned 18 to get it lowered.
That's correct, but you still know you could reduce. There was an avenue that you could pursue legally to reduce your child support, correct?
Right. That's why I went to Attorney General, and that's why the reason why we had this meeting in September.
Well, the step down was that you're talking about was already in place, correct?
Yes.
And the reason why the Attorney General filed their motion is because you were in arrears then, correct? And that's why isn't that correct?
Objection calls for speculation, calls for a legal conclusion.
Sustain.
The question then, I'll restate my question, Mr. Batchelor. When you were involved with the Attorney General back last year, you were in arrears then, correct?
Yes.
But yet you did not hire an attorney until 6 months later, correct?
Could be. I don't remember the exact date.
Well, say from, you didn't hire Miss Pierce until what, March?
March or February. I can't remember.
All right. I have no further questions, Your Honor.
Ms. Pearson, anything further from this witness?
I just have one. When you sought the assistance of the Attorney General in September of 2020, did you have the money to hire a lawyer?
No, ma'am.
Is that the reason you didn't hire a private lawyer?
Yes.
Matter of fact, did you have to borrow money to hire me?
Objection
Yeah.
form.
Sustain. Leading. Don't lead your witness.
That's all I have, Your Honor.
All right, Mr. Schwartz, anything further from this witness?
Nothing further, Your Honor.
Any other witnesses you'd like to call, Ms. Pierce?
No, thank you. I rest.
All right, both sides rest. The motion to dismiss is granted. The motion for attorney's fees is denied. The court will take up any attorney's fees request as it relates to the modification in the modification trial. Ms. Pierce, do you want an entry on this order for, we can do November 19?
Okay, Your Honor, that's
Which
fine.
just will basically say he's found not guilty, or the motion to dismiss is granted in the relevant time period, which would be through the last request for what appears like the last request for violation on the child support was 11/1, and on the medical support it was, let me give you the date, August 3rd, 2021. I'm sorry, there's an August 17, 2021.
Oh, is that August 7? Okay,
All right, we'll see y'all back here at 1:30 on the modification and the request for confirmation of arrears. Just, we're going off the record.
And judgment also. You're
Correct.
Yeah.
Okay.
Thank you, Your Honor.
Thank you all, 1:30.